All right, Deputy McLeish, I'm ready when you are.
Mr. Adams is up first, Your Honor.
Are you ready on Mr. Adams?
I'm ready on everybody, Your Honor. So you can call in whichever order you like.
We'll just go down the docket, keep it easy. Rusty Copeland, CR 22-6. Mr. Copeland is set for pretrial today.
Yes, sir. Your Honor, I don't have any pretrial issues today to bring up for Mr. Copeland. However, I would ask the court to reset us for one more pretrial issue, one more pretrial setting. Mr. Copeland and I haven't had much of an opportunity to visit at length about his case. I intend to do so a week from today, as my schedule will allow it. So if the court would please indulge us with one more pretrial setting, sure would appreciate it.
And is that for purposes of filing any legal pretrial motions, or is that just for purposes of negotiation?
Both.
Both?
Yes, sir.
State, any objections?
No, Judge.
All right, court will grant Mr. Copeland's request and set this for an additional pretrial. Mr. Adams, I've got some availability June 14th, 16th, or July 5th.
Your Honor, I'm going to be in San Antonio for CLE report for the June date. July 5th, I have a docket in Cherokee County that I have to be at, and that's actually two dockets, a morning and an afternoon.
What about July 7th?
I'm here that day, Your Honor. That's fine.
All right, court sets Mr. Copeland for pretrial on July 7th at 1:30 if he's in jail, 9 a.m. if he's on bail.
Yes, sir.
I'm not sure I announced both cases. It's also CR 22-7. Stephen Foster, CR 21-214. All right, Mr. Foster is set for plea today. Are we going forward with plea?
Yes, Your Honor. That is correct. Would you like me to read the terms of the negotiated peace agreement to you?
Yes, sir, please.
Okay. In exchange for Mr. Foster's plea of guilty, the state is going to recommend confinement for 4 years in the Texas Department of Criminal Justice Institutional Division with a fine of $1,500, court costs of $290, and a reimbursement fee of $80.
Any credit time for Mr. Foster?
Your Honor, the judgment reflects time credit for 306 days. Mr. Foster tells me that he has 30 additional days when he was held in Hunt County. And he says that Van Zandt County had a hold on him at the time for that.
I've been locked up since June 20th of last year.
I'm going to recall this case and I'll let you get with Ms. Heisel and
Good.
get some kind of verification before the court can rule on it.
Yes, sir. Hillary, if you want to send me a text message, I think I can get it in this lead box.
All right, go ahead and have a seat, Mr. Foster. We'll call you back up in a moment.
Thank you. That's fine.
Let's go. Vicky Lavorne, CR 21-266. All right, we're set on a couple things. It looks like pretrial, and it appears that Ms. Lavorne has filed a motion to terminate court-appointed counsel. Let me have your announcement on pretrial first, Mr. Adams.
Your Honor, we don't have any pretrial issues to take up. I think we're still waiting for video from Will's Point.
State, do you have any confirmation on that?
No, Your Honor. I know Mr. Adams had reached out to me on this, and I just it slipped under my radar. I will get with Mr. Adams and make sure that we have that worked out.
All right, Ms. Lavorne, are you wanting to urge your motion to terminate Mr. Adams as your court-appointed attorney?
No.
No?
No.
No? Okay, are you withdrawing that motion?
Yes,
Okay, can you tell me why you're withdrawing that motion?
because I spoke to him today.
Okay. All right, if there's nothing else then you need to tell me on that, then the court will grant your withdrawal of that motion. We will reset this case for additional pretrial hearing on July 7th. And if there needs to be a sooner setting, Mr. Adams, you'll let me know and we'll see what we can do.
We will, Your Honor.
Shannon McFarland. All right, Mr. McFarland, this is CR 22-35, set for pretrial.
Correct, Your Honor. We don't have any pretrial issues to take up right now, Your Honor. However, I need additional time with Mr. McFarland to review the materials in this case. I think that I still need to see the state's CAC interview, which I have not yet done. I have a date with Mr. McFarland a week from the day to review the file more thoroughly. And while I'm at it, while I'm here that day, I will also make it a point to go look at the CAC interview in this case. To that effect, I say all that to request another pretrial setting with the court's indulgence.
State, any objection?
No, Your Honor.
All right, court will grant the defense request and set pretrial on July 7th at 9 a.m. I'm sorry, at 1:30. If he's in jail, 9 a.m. if he's on bail.
Okay.
All right, Mr. Adams, I'll recall Mr. Foster once you and the state have a chance to resolve the credit time question. I believe that's all you have. Is that right?
Yes, Your Honor.
All right. We're having a standoff in this life. So I'll recall Mr. Foster once you and the state have a chance to resolve that credit time issue. Next.
Yes, sir. That'll be Mr. and Ms. Cazares with Kendall.
All right, Mr. Miller, if you'll step on up. Good afternoon, Ms. Cazares. How are you?
Doing fine, Jen. How are you?
Hey, I'm doing great. Get over here. All right, this is CR 15393, State versus Kendall. Mark Miller. Is it my understanding that there's an agreement in this case for the state to withdraw its motion to adjudicate with the condition that Mr. Miller is agreeing to a probation extension of 2 years with safety as a condition? Is that correct, Ms. Cazares?
Yes, Judge, that's correct.
All right, state, is that what you're asking for?
Yes, Your Honor. State joins.
Okay. All right, Mr. Miller, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So if you got. All right, you may put your hand down. All right, Mr. Miller, you have an attorney in this case, Ms. Cazares, is that correct?
Yes, sir.
Are you pleased with her representation of you?
Yes, sir.
You feel like you've had enough time to discuss your case with her and have all of your questions answered? And the state has filed a motion to adjudicate your guilt, which means, in other words, a motion to convict you. However, the state is indicating that they want to withdraw that on your agreement with them, that you will extend your community supervision for 2 years and that you will enter into the substance abuse felony punishment facility, also known as safety, as a condition of your community supervision, and that would begin today. Is that the agreement?
Yes, sir.
And has anyone threatened, forced, or pressured you to make you feel like you had to enter into an agreement today?
Okay.
Ms. Cazares, is there anything that I've stated incorrectly?
No, Your Honor, that's correct.
All right, then the court will grant the state's motion to withdraw the motion to adjudicate. Court will extend Mr. Miller's community supervision for an additional 2 years and will order him to attend the safety program as a condition of his community supervision. Ms. Heisel, I've got a motion here, but it's not signed by the state. Have y'all submitted one signed?
No, Your Honor, I'll come sign it when I sign the rest of the paperwork at the courthouse after docket, if that's acceptable.
Okay, all right. All right, Mr. Miller, I will get that signed and sent over to the jail. And you understand that as you go, that you're going to be held in custody until a bed becomes available at that program. You understand that, right? Okay, and you understand that this is a program that could last between 6 months and 9 months. You understand that? There's going to be aftercare for up to an additional 3 months after that. You understand that? And you understand, and if you don't understand, I want you to understand that I'm going to give you this opportunity to go to rehab because I'm assuming that that's what you want to do, that you want to get help with your drug problem. I don't want you to go down to a rehab if you're not genuinely interested in trying to get help with your substance abuse problems. Okay, I don't want that. So if you got a drug problem and you don't want help, safety is not the place to go. If you don't want help, it's the place to go if you do want help, and you're going to go down there with an open mind and a good attitude, and you're going to listen, and you're going to educate yourself, you're going to improve yourself, and you're going to use the tools and resources that they want to give you on how to change your life. You understand? Okay. All right. That's what I expect you to do. So I don't want to hear any reports coming back. I don't want to have any memos or motions coming back from the state saying that you're getting in trouble or you're getting kicked out of the program or anything like that. This is an opportunity for you to make yourself better. Okay. All right. Good luck to you, Mr. Miller. Thanks, Ms. Cazares. Appreciate it.
Ms. Cazares, is there any paperwork for Mr. Miller?
I have no here, he's already signed.
You do have it for the jail?
Well, the judge has signed.
Okay, very good, very good. All right, Ms. Chester's up, Your Honor.
You just have one today. Is that correct, Mr. Fulco?
Correct, Judge.
All right. This is cause number CR 2219, State versus George Walter Fulco, and we are set for docket.
That's correct, Your Honor. I spoke with Mr. Folco. We've gone over the discovery. We just would like to be set on the jury trial docket. There was a previous offer made in the case that Mr. Folco has rejected, and I've explained to him the court's standing rule about if we proceed to jury trial, how he would check in if he gets released from jail, because there will be a motion to reduce bond while he awaits trial filed this afternoon.
All right. And what is the offer that Mr. Fulco has rejected for the record?
It's for 6 years TUC, Judge.
All right. And Ms. Chester, do you believe that you and the state have fully extinguished all of the negotiations in this case?
Based on speaking with my client, yes, Your Honor.
All right, Mr. Fulco. So Ms. Chester has correctly stated what my policy is if right before your trial you decide that you want to take the 6 years, court is going to deny that, and you're going to be put to trial. That even if the state comes in and increases, they file any type of enhancements or anything of that nature, that's a risk that you've taken up until this point, and you understand rejecting their offer. And no one, I'm not telling you you have to take their offer, and you're not being coerced to take their offer or anything like that. I'm just telling you that once the offer comes and goes, I'm not going to allow them to re-extend it to you at a later date, unless there's some circumstances that are extenuating or require that. You understand? All right. The court will place Mr. Fulco then on jury selection docket beginning Monday, June 6th. And Mr. Fulco, if you make bail in this case, then you're ordered to report to the Van Zandt County Courthouse on the 2nd floor, and a member of my staff will be there to give you more information. Okay.
Thanks, sir.
You're welcome.
First one.
Good afternoon, Mr. Manning.
Hey, Judge.
All right, is this Mr. Richardson?
Yes, Judge. Yes, sir.
All right, this is cause number CR 21-141, State versus Caleb Reed Richardson, set for pretrial.
Yes, Judge, at this time, we have no contested matters to be heard before the court. We ask to be set on the docket call.
All right, I've been setting June 14th and 16th. Do you need more time than that?
I don't believe so, Judge. We've previously gone over the discovery at my office, so unless the state has updated their discovery, I think we should be good to go on the 16th.
All right, court will set Mr. Richardson then for docket call on June 16th. That is at 1:30. If Mr. Richardson makes bail, it will be at 9 a.m. in the courthouse.
Thank you, Judge.
You're welcome, sir. Do we have Mr. DeMonte Graves in the courtroom?
Not at this time, Judge.
Okay, are we going to bring him up at all?
I'm sorry.
Are we going to bring him up?
That's my understanding. Thank you.
Okay. All right. Court will have an announcement whenever he arrives.
All right.
All right, this is cause number CR 2234, State versus Lance Davis McCormick, set for pretrial. Go ahead, Mr. White.
Your Honor, we're set for pretrial, as you said, and I filed a motion to suppress on this. I'll get with Ms. Heisel and discuss the issue that I have. And I'm not exactly sure how long this will take. I don't think it's going to require some testimony.
All right, court will set the motion to suppress for hearing. We'll set this on June 28th. It's going to be set in the AM though, Mr. White. That looks like I only have AM settings available that day.
Yes, sir.
So we'll set that at 9 a.m. on Tuesday, June 28th.
Your Honor, we need just a few minutes to cycle some more people back in here. If that's
Yes, ma'am.
okay.
Yes, ma'am. Mr. Manning? You ready? All right, is this Mr. DeMonte Graves?
It is, Judge.
All right, this is cause number CR 22165. Understanding that Mr. DeMonte Graves wants to enter into a plea today with the state. The state had brought this to the court's attention, and I believe the state had filed information in this case to respond to the request to resolve the case by Mr. DeMonte Graves. However, at this time, the court believes that it should recuse itself in this matter. I believe that both myself and Judge Winters are both recusable in this due to the nature of the allegations that have led to Mr. Graves being placed in custody. So court is not going to be able to facilitate a plea agreement today. And it's also my understanding that there's been no evidence turned in by the law enforcement agencies to support the plea for Mr. DeMonte Graves at this time. So what I can do, Mr. Manning, is I can immediately recuse myself, ask my presiding judge to appoint a judge to hear this matter. And then I believe Ms. Heisel or yourself can try to determine if there's going to be enough offense reports or case reports turned in to support a felony plea. So I wanted to make that announcement, and I'm sorry that we got you set and ready to do this today, but it was just brought to my attention earlier today that he was set for a plea and that we didn't have really any information to support the plea. Okay.
Judge, we do understand though that he did file and has completed the paperwork for waiver of arraignment, as well as the states one, which is a stipulation of evidence on which the court, can proceed on his plea. In regards to the issue to recuse, we would request that he be set at the earliest possible date. I believe there's a June 2nd date next Thursday that's possible to have him set. The reason being is that he is set up to go voluntarily turn himself into a mental health facility in Tyler, where he has received mental health help in the past. As part of the conditions of his probation is to be have his voluntary turning into the Tyler Northeast mental facility, as well as to continue on his medications that he's been put on while he's been in custody here in Van Zandt.
Okay, I can't set him for a specific date because that's going to be subject to the assigned judge's scheduling on whether that judge is going to be available or not. I can set it for a status on June 2nd to see if we can have a judge assigned and to conduct a plea if that judge approves that on that date. I can do a status, but the best that I can do.
Judge, I would appreciate that, just so we can keep a thumb on this. As you know, mental health issues in the jail are not always enhanced by treatment in jail, and so we want to get him to appropriate care facility as soon as possible. So we request we keep that on the earliest possible date.
All right, so the court will set Mr. DeMonte Graves for a status on arraignment and plea. We'll set that June 2nd. I will execute the recusal today at the conclusion of the docket, and we'll provide any information we get to both the counsel for the state and to you, Mr. Manning, on who the assigned judge is and if they can be available on June 2nd.
Yes, Judge. Judge, I believe that who's on business may be excused.
Yes, thank you, Mr. Manning.
Yes, Mr. Stevens, you're still working, is that correct? One signature. Okay. All right, that's your third, sir. Mr. Rodriguez will step up to the podium, sir.
Who do you have with you, Mr. Stevens?
Brad Rodriguez, Your Honor.
All All right, this is cause number CR 2269. Is Mr. Rodriguez entering a plea today?
Judge, we are amending the conditions of probation and taking away his back time credit, basically amending his probation, going to have him return to probation, be evaluated for a psychological evaluation if he needs to be in the MHMR program. But that's the plan, Judge.
Okay, tell me how many days that are going to be as a I need to know that specific agreement.
307 days.
Are there any other modifications?
No, Your Honor, it's for the submit to evaluation by public or private healthcare provider for his psychological situation.
All right, Mr. Rodriguez, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, Mr. Rodriguez, you heard what Mr. Stevens, your attorney, has stated to the court. Is that your agreement today?
Yes, sir.
Are you pleased with Mr. Stevens' representation as your attorney in this case?
Yes, sir.
Feel like you've had enough time to discuss your case with him, have all of your legal questions answered?
Yes, sir.
All right, has anyone threatened, forced, or pressured you to enter into this agreement today?
No, sir.
All right, Mr. Stevens, you believe Mr. Rodriguez to be competent to enter into this agreement?
Yes, sir, I do.
All right, so the agreement is that the state is going to withdraw its motion. It's going to ask the court to amend the community supervision conditions to require Mr. Rodriguez to serve 307 days in the jail. Is that correct?
Yes, sir. And he has a back time credit for the 307 days. And for the record, Your Honor, I did explain to Mr. Rodriguez the bottom line of 307 days, so to speak, that if he were to be violated later down the road, that 307 days back time credit is gone. And he understands that.
And counsel, correct me if I'm wrong, but I believe that the statutory maximum ACOP or as a condition of probation on jail credit, it only extends to 180 days. Is that correct?
Judge,
I don't know that the court can order someone to serve more than 180 days in jail as a condition of probation, unless the law has changed on that.
that's what you.
Okay.
I'm sorry, Ms. Heisel.
Judge, I was just gonna say, we would defer to the court on that. I can't seem to locate my code right this second. But I would defer to the court on that. And we can have the conditions of probation changed to reflect 180 days. And then Mr. Rodriguez would retain the back time credit for the additional days.
Is there any other counsel in the room that has the code available or could assist us?
No, I don't see anyone, Judge. I mean, I see counsel in here, but I don't see any codes.
What are we trying to do? How, if we can.
We will go ahead and do 307 days as a condition of probation and then maybe back out and then just get people to 80.
Judge, I believe you're correct. I didn't realize Mr. Rodriguez had more back time than that.
Like I said, I know that's the law unless it's been amended or changed in the last couple of legislative sessions. And I'm not aware that it has been, so. All right, so the court will order Mr. Rodriguez to do 180 days in the jail as a condition of community supervision. The court will issue him credit for that. The court will also order him to attend any psychological evaluation or counseling that is recommended after that evaluation. And court will approve Mr. Rodriguez being placed back on community supervision as is the recommendation of the DA's office. Is there anything further, Mr. Stevens?
No, Your Honor. Thank you.
All right. Thank you, Mr. Rodriguez.
Thank you. Jesse, come on.
All right, Mr. Ashmore, who do you have with you?
Judge is Mr. Wagner. We just need our next available, and he's refused all plea offers. Jury trial is his request.
All right, this is cause number CR 2168 and 341, State versus Jesse Wagner Henry, and we are set for a docket call. Mr. Henry's been charged with continuous violence against the family and also bail jumping, failure to appear. And Mr. Ashmore, understand that Mr. Henry has rejected the plea offers in this case. Can you tell me what the offers are that Mr. Henry has rejected?
My understanding is that he believes there's a affidavit of non-prosecution on file that should significantly change the state's position. Before he absconded and was charged with bail jumping, I believe the last offer was 7, and it might have been as low as 5 because of the allegations of enhancement and enhanceability. And those offers were refused in previous hearings. Ms. Heisel may have some other notes, I'm not sure. And we've not really had significant communication about any resolution of the bail jumping, because it's always been my understanding from Mr. Wagner that he's refused and is going to continue to refuse all offers. He wants the case no billed or dismissed for some, I'm not exactly, Judge, and I've explained to him that the only way to do that is through a jury trial, right? Which is what he has asked me to request from this court on every occasion. And that is our request here.
Ms. Heisel, can you inform the court as to the offers that Mr. Henry's rejected?
Your Honor, this case is Mr. Woodwikes, who is out for medical procedure today. I do have notes in here that Mr. Woodwike's offer was for probation on the assault family violence prior to the bond jumping being filed. However, there are no notes in the bond jumping as to any subsequent offers after that. It is our policy that, if you abscond, that you don't then get probation. So I would assume that there would be pin time offers made on that, but I have no documentation of exactly what that was or when that was offered.
Okay, thank you, Ms. Heisel. Anything further, Mr. Ashmore?
Yeah, Judge, Mr. Wagner's making some request about some sort of bond reduction, and I'm advising him here on the record that all that's going to do, one, with the fact that he's absconded, alleged to have bail jumped with a PR bond in place, and that just a minute, Mr. Wagner, and the fact that he's going to have a hold on him for that any kind of request for a reduction is just going to, even if a PR bond is granted on the bail jumping, it's just going to negate his time served, and that's not a good idea. So I don't advise we do that. I think we just need to be reset for a trial as soon as possible, Judge.
Well, and there's no motion filed for bail reduction at this time, is that correct?
Nothing yet, and I'll discuss with him, not on the record, that I have to file a motion, so I have to discuss that and file that in the appropriate order.
All right, since there is no motion filed before the court will set this for jury selection beginning June 6th.
Thank you, Judge.
And if a motion is filed, then Mr. Ashmore, then you just notify the court coordinator and we'll get it set.
Thank you, Judge. Judge, we're ready on Mr. Shelton. Come on up here, Mr. Shelton.
Donnell Shelton, CR 2247.
And 48.
Oh, thank you. And 48. Mr. Shelton, for pretrial on both cases. Go ahead.
Judge, I'm gonna ask the court and I'm gonna ask the state to not oppose. I had some trouble with Adobe formatting today and I filed a pretrial motion late. It's a big pretrial motion, but the gist of it is the state's turned over the video evidence they believe they have, and I know they've been diligent. However, one of the discs that we received is for a different case. So it doesn't apply to this case. It has to do with a theft. Even though it's got our case numbers written on it and Mr. Shelton's name written on it. So that's not helpful. And it's just probably something inadvertent. And then there appear to be at least 3 officer body cams that may not have been collected by the, there were multiple agencies responding to this incident. And we have the body and dash cams of only 2 officers. There were at least 3 others that we don't have. And I'm asking the court for an additional pretrial so I can work that discovery issue out with the state prosecutor's office, Judge. And I haven't had a chance to bring it to their attention because I didn't fully know, and I wanted to go through all of the documents and film we had over the course of the last setting to ensure that of what exactly it was that I did not have.
State, any objection?
No, Your Honor, this is the first we're hearing of any issues with the disc, so we would be happy to work with Mr. Ashmore to get that resolved. But like I said, it's the first we're hearing of it.
All right, court will reset Mr. Shelton for an additional pretrial, so y'all can work out those discovery issues.
Thank you, Judge.
The court will reset that. You want to do July 5th or 7th, Mr. Ashmore? Give you more time.
I would, yes, on this one, I would ask for more time because this is a serious case with some very significant consequences, 1st-degree felony. We do the 7th, Judge.
All right, court will set Mr. Shelton for July 7th in both causes.
Thank you so much. Thanks, John. See you soon. Judge, I'm going to need just a minute to visit with Mr. White. We'll be ready to plead. Thank you.
Yes, sir. Thank you.
And Judge, I got notification that Mr. Adams and Mr. Foster are ready to try again.
Okay, do we have a clarification on the time credit issue?
Your Honor, I believe that they now understand how we calculated our time credit and are in agreement with the 306 days.
Okay, Mr. Foster, if you'll step up, sir. All right, let's see. Back on the record, CR 21-214, State versus Stephen Leslie Foster. Mr. Ashmore, Mr. Adams, can you clarify the issue on the credit time?
Sure, Your Honor. Ms. Heisel emailed to me a summary or explanation of how his time was credited, the dates from the 2 different counties. I reviewed that with Mr. Foster, and while he's not 100% confident that that is correct, but we are not raising any objections to what the state has calculated. We're ready to proceed with the judgment the way that it is. It's
All
not
right.
about the little file.
You agree with that, Mr. Foster? Okay. All right, Mr. Foster, if you'll raise your right hand and place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may lower your hand. Your name is Stephen Leslie Foster, is that right?
Yes, sir.
And Mr. Foster, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes.
And have you ever been diagnosed with any type of mental condition?
Yes, depression.
Are you currently on any type of medication or undergoing treatment for depression?
I'm on medication.
Okay. And do you feel like you have a rational thought and understanding of the proceedings as they are against you today?
Perfect.
In this case, you're represented by your attorney, Mr. Adams. Are you pleased with his representation of you?
Very.
You feel like you've had enough time to talk with him about your case and have all of your legal questions answered?
Yes, sir.
Anything about the paperwork that you've read and signed today that you do not understand?
No, sir.
All right, Mr. Adams, you believe Mr. Foster to be competent today?
I believe he's competent, Your Honor.
You've explained to him his legal rights as they pertain to this case.
Yes, sir, that's correct.
You believe he understands them?
I believe he understands, Your Honor.
All right, Mr. Foster, you are charged by indictment with a state jail felony offense of theft of property less than $2,500 enhanced by 2 or more previous convictions. A state jail felony in Texas has a range of punishment of not less than 6 months in prison or more than 2 years in prison, and a fine of not more than $10,000. In this case, the plea agreement, I'm sorry, is this enhanced to a third degree, Mr. Adams?
It's enhanced to a second degree, Your Honor.
It's enhanced to a second. Well, let me pull that case up. Is that by Brooks or is that in the indictment?
It's in the indictments, alleged enhancements in the indictment.
Okay. Just pull this case up. You see that document, Mr. Foster?
Yes, sir.
Okay, I'm gonna go back here and correct some things I said. You have been charged by indictment with a state jail felony offense of theft of property less than $2,500, enhanced with 2 or more previous convictions. And furthermore, the state has included additional enhancement paragraphs as indicated here in the indictment. Have you reviewed this indictment with your attorney, Mr. Adams? All right, and so Mr. Adams, let me see in here. So you're indicating that this is a state jail enhanced to a second degree?
Yes, Your Honor.
So the primary offense is on April 12th of 2021. State isn't, so what's the value ladder for state jail on April 12th, 2021? Is it capped at 2,500 or is it 2,500 to 30,000?
Judge, for state jail, it is 2,500 to 30,000 or 2,500 to previous convictions. I'm not sure I'm seeing the issue you're seeing in the indictment, Judge. Again, this is Mr. Woodwide's case.
Let me read this real quick. Assuming here that the enhancement paragraph 1 contains the 2 previous theft convictions, and then that the enhancement paragraph 2 is laying out. So the state jail is enhanced to, so it becomes state jail by enhancement paragraph 1. And then state jail is then further enhanced by 2 non-state jail felony offenses. Cause number 16002, and then sure these dates are correct. Okay, it appears to be sequential. So we have a state jail felony enhanced to a third with two state jail felony offenses. Is that correct, Mr. Adams?
Your Honor, that's the way that I see it, yes.
Okay. All right. So Mr. Foster, it's just I'm not used to seeing it laid out like this. Usually I would see the primary offense would contain the two theft here, and then enhancement would be here. I think that's maybe just what threw me off. So, all right. So Mr. Foster, the offense is a state jail felony by virtue of the primary allegation plus the two previous theft convictions contained in enhancement paragraph 1, and then the state is seeking to increase the enhancement. Intending to increase the range of punishment to that of a second degree by alleging two other final convictions in enhancement paragraph 2, which would make this a second degree felony offense. And a second degree felony offense carries a range of punishment of not less than 2 years in prison or more than 20 years in prison, and a fine of not more than $10,000. Do you understand that full range of punishment? All right. And you understand that the plea agreement is that you would plead guilty to that primary offense. You'd be pleading true to all of the enhancement paragraphs, and that would enhance your range of punishment to 2 to 20. And the plea agreement is to fit within that range of punishment to 4 years confinement in the Texas Department of Criminal Justice, plus fine, court costs, reimbursement fees, with you receiving the 306 days credit towards your sentence. Is that right? All right. Understanding all of that, do you still wish to go forward with this plea, Mr. Foster? All right. At this time, Mr. Foster, I'm going to ask you, how do you plead to theft of property less than $2,500 with 2 or more previous convictions?
Yes, sir.
And how do you plead to the enhancement paragraphs contained in the indictment? Are those enhancement paragraphs and their allegations true or not true?
Yes, sir.
They're true?
Sure.
Okay. And are you pleading guilty and pleading true because you are guilty of committing that offense and the allegations in the enhancement paragraphs are true?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty or true today, Mr. Foster?
Yes, sir.
All right. Court will accept the defendant's plea of guilt at this time. Mr. Adams, any objection to the state's evidence?
No objections, mark it off.
All right. State's evidence as provided to the defense is admitted as State's Exhibit 1. Court does take judicial notice of the defendant's judicial confession. Ms. Heisel, if you can give me the evidence to support the plea at this time.
Yes, Your Honor. Mr. Foster was at Walmart where he had a receipt. I'm not sure if he picked that up in the parking lot, had it from a previous encounter at Walmart, not sure. But he enters the store with a receipt from a previous transaction. Walmart security sees him on camera going around the store collecting items based on that receipt. And they intervene at customer service where he is attempting to exchange or refund the items that he picked up in the store with the receipt that was found to take the cash and receive a cash refund for that. They intervene, they stop, they call Canton PD, and Mr. Foster admits to them on scene that that is what he was trying to do, was trying to basically defraud them of the cash. The value on this was $138.
Thank you, Ms. Heisel. Any objection to that summary, Mr. Adams?
No, Your Honor.
All right. Anything further from the state?
No.
Anything further from the defense, Mr. Adams?
No, Your Honor, we rest.
All right. Based on the evidence presented, the court will find that there is enough evidence to convict Mr. Foster. The court will follow the plea agreement. The court hereby convicts Stephen Leslie Foster of theft of property less than $2,500 with 2 or more previous convictions. The court will find the enhancement paragraphs to be true. The court will assess the punishment in accordance with the plea agreement at 4 years confinement in the Texas Department of Criminal Justice Institutional Division, assess a $1,500 fine, $290 court cost, $80 reimbursement fee, and the court will award Mr. Foster 306 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Foster, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'll have you step over with Deputy McLeish to be fingerprinted. Good luck to you, sir.
Let's not meet at the courthouse. This card. Your Honor, that's all I had over here, but I'd be excused.
Yes, and your client is over here at the courthouse.
Thank you.
Good afternoon, Ms. Thompson.
Good afternoon, Your Honor.
This is cause number CR 2204, State versus Anne Marie Carter. And I show that we are set for docket call, possibly a plea. Is that correct?
Your Honor, it's plea today.
Okay, can you tell me what the terms are, Ms. Thompson?
Yes, sir. She will be on straight probation for 5 years, 10 years if she violates, $5,000 fine. Court cost, Your Honor, is $290.
All right, any reimbursement fees?
Reimbursement fees is $1,490. State agrees to $12.45 a possession of marijuana, 2 ounces. A possession of controlled substance under 28 ounces, or 28 grams, I'm sorry. Get rid of a possession under 4 grams. Get rid of a tampering with physical evidence. And to get rid of another possession of controlled substance under 4 grams.
All right, and you said the reimbursement fees, did you say 1,490?
Yes, sir.
And you said it is, the plea is 10 years TDC, probated for 5 years community supervision, or did I hear that? Okay. All right, Ms. Carter, if you'll raise your right hand, I'm gonna place you under oath. Ms. Carter, do you swear that the testimony that you give the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, may put your hand down. Make sure you speak up loudly for me, Ms. Carter, so that I can hear you and so that my court reporter can take down everything that you say, okay?
Yes, sir.
All right, thank you. All right, your name is Anne Marie Carter, is that right?
Yes, sir.
Ms. Carter, how old are you?
31.
31? And Ms. Carter, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Ms. Ann Thompson. Are you pleased with her representation of you?
Yes, yes, sir.
Do you feel like you've had enough time to discuss your case with her and have all of your legal questions answered?
Yes, sir.
Is there anything that you do not understand about the paperwork that you've read and signed today?
No, sir.
Ms. Thompson, do you believe Ms. Carter to be competent today?
She is competent, Your Honor.
Have you explained to her her legal rights and also the nature of the plea and how probation works?
We have, Your Honor. We discussed that.
Do you believe that she understands everything today?
She does, Your Honor.
All right, Ms. Carter, you are charged by indictment with a second-degree felony offense of possession of a controlled substance in penalty group 1, greater than or equal to 4 grams, but less than 200 grams. That does carry a range of punishment, not less than 2 years or more than 20 years confinement in the Texas Department of Criminal Justice, and a fine not to exceed $10,000. You've heard Ms. Thompson recite the plea agreement in this case, which is that you would plead guilty to this case, to this charge, and the state would recommend that your sentence be assessed within that range of punishment at 10 years confinement in TDC, with that being suspended and you being placed on probation for 5 years, plus you paying fines, court costs, reimbursement fees, and then the state would be dismissing several other cases that Ms. Thompson read. Is that your understanding of the plea agreement?
Yes, sir.
Understanding all of those things, do you still wish to go forward with the plea?
Yes, sir.
All right, Ms. Carter, at this time, I'm going to ask you, how do you plead to possession of a controlled substance in penalty group 1, greater than or equal to 4 grams, but less than 200 grams?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened or forced or pressured you to plead guilty today?
No, sir.
All right, the court will accept the defendant's plea of guilt. Ms. Thompson, any objection to the state's evidence?
No objection, Your Honor.
The state's evidence is admitted and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
Ms. Heisel, can you go ahead and give me a summary to support the plea?
Yes, Your Honor. Miss Carter was driving in Wills Point, where Wills Point noticed that she was driving significantly under the speed limit, veering within her lane. They executed a traffic stop for reckless driving. She exhibited very nervous behavior. They asked if they could search her vehicle, and she replied that that would be a waste of time. Then while they were running her driver's license, Miss Carter gave consent to another officer on scene to search her vehicle. They did search her vehicle and found a small pouch inside with baggies with dark brown tar substance, green leafy substance, another package of green leafy substance, crystal clear like substance, all within that packaging inside of her car, suspected to be heroin, meth, alprazolam, and marijuana. The lab only tested one of those containers, Your Honor, and let me get the exact amount for you here. 4.31 grams of methamphetamine inside one of those plastic bags, clear crystals. The state is taking into consideration all other related charges due to the lab not testing those individual substances.
All right, thank you, Ms. Heisel. Any objection to that summary, Ms. Thompson?
No, Your Honor, that's correct.
All right, then based on the evidence presented, the court will follow the plea agreement in this case and find that there is sufficient evidence to convict Anne Marie Carter of possession of a controlled substance in group 1 between 4 grams and 200 grams. The court assesses her punishment at 10 years confinement in the Texas Department of Criminal Justice Institutional Division. The court will suspend that sentence on this date and place Ms. Carter on 5 years community supervision, order her to pay a $5,000 fine, $290 court costs, order her to pay reimbursement fees of $1,490. The court will take into consideration and dismiss under section 1245 charges of possession of marijuana less than 2, possession of controlled substance less than 28 grams, 2 charges of possession of controlled substance between 1 and 4 grams, and 1 tampering physical evidence as reflected in the judgment and plea admonishments in this case. Ms. Carter, you understand how probation works, do you not?
I believe so, yeah.
Have you been on probation before?
No, sir.
You haven't? Well, you have quite a responsibility on probation. A lot of people think that probation means that someone gets a slap on the wrist, but it's quite the opposite. It means that you have to go in and you have to be responsible, accountable. You have to hold down a job. You have to pay your fees. You have to remain drug-free. You have to do your community service. You have to take classes. You have to do everything that's required of you in those conditions in order to keep your freedom. And so it's not easy. It takes being an adult. It takes being responsible. It's easier to be locked up like an animal and just sit in a cage and be told when to eat, when to go outside, when to go to the bathroom, things of that nature. All right. So this is an opportunity. It looks like Ms. Thompson's got 5 other charges, plus this serious possession, 4 to 2, got you an opportunity at probation. So the ball's going to be in your court on whether you succeed or not. So you better take it serious, because sentence has already been imposed on you. Your sentence has already started. It's 10 years in prison. And if you violate, if you go out and you get high, or you don't show up to do your community service, or you don't pay, or you drink alcohol, you do anything that violates any of these conditions, the state can bring you back to court, and if they prove to me that you violated your probation, then your sentence is 10 years in prison. That's a long time. That's a long time, especially for a young lady. You understand?
Yes, sir.
All right. You're hereby remanded to the custody of the Van Zandt County Community Supervision Corrections Department so they carry out the terms and conditions of the sentence. Step over with Deputy McLeish, and she will take your fingerprint, and then you'll speak with someone at probation, and they'll give you more information. Yes, ma'am, I'm ready.
Your Honor, the remaining attorneys that we have are still doing some work, but we do have Mr. Hugh Williams in the room to speak with you if you're ready for him.
Yes, bring up Mr. Williams up.
Mr. Williams, you'll come up to the podium.
All right, Mr. Williams, this is cause number CR 19293. My note says that you were to appear today to enter into the safety program. Is that correct?
Yes, sir.
All right, and Ms. Burns, is this a modification of community supervision?
Yes, sir, it is. He has agreed to go to safety, so therefore we just amended this
Okay.
condition.
Okay, is that the only amendment to his conditions? Is he being extended at all?
No, sir.
Okay, so it's just amending to include safety. Okay,
Right, and a new payment plan on court costs, fine, and attorney fees.
okay, who's the attorney? Because I don't have attorney fee on here. And obviously, and there's not an attorney there with him. Do you have an attorney in this case, Mr. Williams?
No, sir.
Brent Gimbel was his attorney when he pled to probation.
Okay, but he's not appointed to him now. Is that correct? There's not a motion to revoke. Is that correct?
He's just agreeing to go.
Okay,
and
so
he's
there's,
not following the motion to revoke.
okay, so what new costs would he have? Just, is there any filing or any motions filed, or would there be any new costs whatsoever?
According to the district clerk, there's $5.16 in court cost, fine in the amount of $25, attorney fees in the amount of $109.84, totaling $140 at $25 a month, once he's released.
Judge, I wonder if that's outstanding from the original plea.
Yeah, I wondered that as well, so. So it shouldn't really be a modification to include new fees. It's just a confirmation of what he still owes.
Previous fees that he still owes.
Okay, and is Mr. Williams going to be on community supervision after he completes safety?
Yes, sir.
Okay, all right. All right, Mr. Williams, if you'll raise your right hand, I'm going to place you under oath. Mr. Williams, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand up. All right, your name is Darrell Williams, and you're currently on community supervision here in Van Zandt County, is that correct?
Yes, sir.
Mr. Williams, are you asking this court to amend your community supervision conditions to allow you to go to the substance abuse felony punishment facility, also known as safety, which is a drug rehab program run by the Texas Department of Corrections?
Yes, sir.
Okay, and why are you wanting to do that?
Because I need help.
Do you have a drug problem?
Yes, sir.
What's your drug of choice?
I'm doing a choice.
Methamphetamine. And how long have you been on methamphetamine?
On and off for 11 years now.
And has anyone from the community supervision department or anyone else, for that matter, threatened or forced you or told you you had to agree to go to drug rehab like safety?
No, sir.
Is this something that you're wanting to do because it's what you want to do?
It's what I have to do. It's what I need to do.
It's what you have to do. And if I approve this and I sign the order that allows you to go down there, you're going to go down there with a willingness to learn how to combat your addiction.
Yes, sir.
Do you have kids?
No, sir.
No. Are you married?
No, sir.
Do you have a mother or father that love and support you?
Yes, sir.
Do you have a job?
Yes, sir.
What kind of work do you do?
I do construction work.
And it seems to me that you understand because you said that you have to. You're saying that you have to because you know that's what you have to do in order to get a hold of your conviction, or you're saying that you have to because someone's making you?
I'm saying I have to because my addiction is gonna kill me. It did. The relapse that led me here. I OD'd and was on a ventilator for almost 48 hours. It did kill me. So it's going to kill me if I don't get it under control.
So you've got an opportunity here to get another lease on life. Is that right?
Yes, sir.
Okay. All right, Mr. Williams. Well, I'll commend you for you coming to the realization that this is what you have to do, not because someone's making you, but because you choose to live. That's what it sounds like to me. All right.
Yes, sir.
Okay. Well, that's great news. That's for you and for your family. All right. The court will approve Mr. Williams' modification of his community supervision conditions and order him to attend the SafeP program. And the court will confirm that he's ordered to pay any balance of financial obligations previously imposed, including court costs, fines, and attorney fees. So, Mr. Williams, you'll step over with Ms. Burns, and she'll have you sign your form, and then she'll send that form to me, and then I'll get that signed. And you'll remain in custody today. And as soon as the bed opens up, then you'll be sent to that program. And I wish you the best of luck in going down there, educating yourself and improving yourself. And ask that you just really genuinely take advantage of everything that program has to offer. I've talked to a lot of people who have stood in your exact shoes and gone down to that program, and they've come back and they've told me what great things that they've learned about themselves and their addiction, how to cope with it, and how to continue to fight it, as it is a lifelong addiction. And so I know that they have the capability to make you a better man when you get down there, if you're willing to accept it. And I think that you are. So I wish you the best of luck, sir.
Yes, sir. Thank you.
You're welcome. Step over there with Ms. Burns. All right, Mr. Stevens, are you ready on Mr. Hilton?
Yes, sir, I am.
All right, Mr. Hilton, if you'll step up. All right, you're Tony Leslie Hilton Jr., is that right?
Yes, sir.
Mr. Hilton, if you'll raise your right hand. Mr. Hilton, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, you may put your hand down. Mr. Hilton, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
And have you ever been diagnosed with any type of mental condition?
Yes, sir.
In this case, you are represented by your attorney, Mr. Bill Stevens. Are you pleased with Mr. Stevens' representation of you?
Yes, sir.
Feel like you had enough time to discuss your case with him and have all of your legal questions answered?
Yes, sir.
Anything about this paperwork that you've read and signed today that you do not understand?
Yes, sir.
Mr. Stevens, do you believe Mr. Hilton to be competent today?
Yes, sir, I do.
And have you explained to him his legal rights?
Yes, sir, I have.
Do you believe that he understands those rights and everything that he's read and signed today?
Yes, sir, he does.
All right, Mr. Hilton, you're charged by indictment with a state jail felony offense of theft of property less than $2,500 with 2 or more previous convictions. A state jail felony in the state of Texas has a range of punishment of not less than 6 months or more than 2 years in prison and a fine not to exceed $10,000. It appears that the plea agreement in your case is that you would plead guilty to that offense. The state's recommendation on your sentence is 13 months in state jail prison with a $500 fine. You would also be ordered to pay court costs, reimbursement fees, and you would receive 390 days credit towards your sentence for the time that you have spent in jail on this cause. Is that your understanding of the plea agreement?
Yes, sir.
All right. Then, understanding all of that, do you wish to go forward?
Yes, sir.
All right, Mr. Hilton, then how do you plead to theft of property less than $2,500 with 2 or more previous convictions?
Guilty.
And Mr. Hilton, are you pleading guilty to that offense because you are guilty of committing that crime?
Yes, sir.
And the prior convictions alleged in your indictment, those are all true. Is that correct?
Yes, sir.
All right. And Mr. Hilton, has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
All right, court does accept the defendant's plea of guilt at this time. Mr. Stevens, any objection to the state's evidence?
No objection.
All right, state's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state,
No, Your Honor.
from the defense?
No, you want to rest in place.
Court will review the evidence. I do have that here, Ms. Heisel. All right, the court has reviewed the evidence and I find sufficient evidence to convict Mr. Hilton of this offense. Court will follow the plea agreement in this case. Court hereby convicts Tony Leslie Hilton Jr. of theft of property less than $2,500 with 2 or more previous convictions. The court assesses his punishment pursuant to the plea agreement at 13 months confinement in the State Jail Division of TDC, orders him to pay a $500 fine, $290 court cost, and $85 reimbursement fees. The court awards him 390 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Hilton, you hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step over with the deputy to be fingerprinted. Good luck to you, sir.
That's it for me, Judge. I'll be excused.
Yes, sir, you may be excused. Good to see you. Thank you for being here, Bill.
Thank you.
You're welcome.
Thank you, Ms. Heisel, for doing the papers. Appreciate it.
Thank Miss Abney, not me. She's the whiz.
Thank her for me.
Yes, you do. You ain't doing nothing to get me out of this damn cell, man.
All right, Mr. Adams, I believe we have a moment. If you want to go ahead, bring your client up. All right, court calls cause number CR 2226. You may. All right, Mr. Howell, if you will, raise your right hand, sir. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right, let me put your hand down. Your name is Joseph Michael Howell, is that right? And Mr. Howell, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? In this case, you are represented by your attorney, Mr. Mitch Adams. Are you pleased with his representation of you? Feel like you've had enough time to discuss the case with him and have all of your legal questions answered? Is there anything about this paperwork that you've read and signed today that you do not understand? And Mr. Adams, do you believe that Mr. Howell is competent today and that he understands his rights, he understands the law as it regards his case, and that he also understands the advantages and disadvantages of a deferred adjudication plea?
Yes, Your Honor, I'll answer each of those in the affirmative.
All right, Mr. Howell, you are charged by indictment with a third-degree felony offense of assault of a family or household member by impeding breath or circulation. A third-degree felony does carry a range of punishment between 2 years to the maximum 10 years and a fine of not more than $10,000. I see that the plea agreement in this case is that you would plead guilty to that charge. The state would in turn recommend that you not be convicted today, but rather you be placed on deferred community supervision for a period of 5 years, with you paying a $3,000 fine, $290 court cost, and being ordered to pay $860 in reimbursement fees. Is that your understanding of the plea agreement, Mr. Howell? Yes. Understanding the plea agreement, understanding deferred adjudication and the charge, you still wish to go forward with the plea? All right, Mr. Howell, how do you plead to that crime? You're pleading guilty because you are guilty of committing that crime? Has anyone threatened, forced, or pressured you to plead guilty today? All right, the court will accept the defendant's plea of guilt. Mr. Adams, any objection to state's evidence?
No objection.
All right, state's evidence is admitted, and the court does take judicial notice of the defendant's judicial confession. Anything further from the state, Ms. Heisel?
No, Your Honor.
For the defense, Mr. Adams?
Nothing further.
All right, court's going to review the evidence. All right, the court has reviewed the evidence, and I find enough evidence to convict Mr. Howell of this offense. The court will follow the plea agreement in this case. The court hereby defers a finding of guilt, places Mr. Howell on 5 years community supervision, orders him to pay a $3,000 fine, $290 court cost, $860 reimbursement fees. All right, Mr. Howell, you're hereby remanded to the custody of the Community Supervision and Corrections Department so they carry out the terms and conditions of the sentence. Deputy Phillips. Deputy Phillips. Odie, can you fingerprint Mr. Howell for me? Yes, sir. All right, Mr. Howell, you'll step up here. Have you fingerprinted by the deputy, and after that, Mr. Waddell will somewhere roaming around the home. Right now. Right now. All right, Mr. Ashmore, are you ready?
Judge, I am. Mr. White and I are gonna unfortunately have to ask for a reset. We need to work some things out with regards to how he'll be contacted on probation. We have a 3 deferred offer that we want to accept. The court may know that Mr. White lost his father and is.
Just hang on. Is Mr. White there in the courtroom?
Yeah, he's right here. Come on over here.
All right. Yeah, go ahead and bring him up. Give me just 1 second, okay, Mr. Ashmore, just 1 second.
Yes, sir. Yes, Judge.
I'm sorry, Mr. Ashland, I didn't mean to interrupt. All right, so this is.
Oh.
PR 346 versus code PY. What are the issues that was proposed and you'll need to work through?
Mr. White has lost his father and has no home at the time of his arrest, which is part of the issue that led to the failure to appear. And I don't know if the court remembers, it was a pretty nasty winter day and he was out front of the courthouse with some COVID-like symptoms and didn't get his reset slip. Anyway, he's here, he's safe. We have a deferred offer. He's a first-time offender on a possession of a controlled substance, but we don't have a home, a permanent or even a semi-permanent address for Mr. White to receive and have probation check on him. So we're going to have to ask for a reset while we try to run a few things to ground so that he's in as much as we can make it so, a position for success in his probation.
Set this for the middle of June, those 14th or 16th days.
14, I think I know I'd like to do it faster, but that might be that might be what it takes to get this done.
All right, so let me set this for June 14th. If Mr. White works something out before then we can move him on to.
Yes, Judge.
June 2nd, which would say it's 22. Next year.
Going there right now. Ms. Heisel, I'll just hold on to the plea paperwork until we get that squared away. Thank you, Judge. Thank you, Ms. Heisel.
Yes, sorry to hear about your loss, Mr. White.
May I be excused, Your Honor?
Yes, thank you, Mr. Ashland.
Thanks.
Please, does that conclude our business and intention of justice today?
Judge, I'm having a real hard time hearing you, so I'm assuming that Deputy McLeish is also.
I'm sorry, no, I didn't hear anything.
Oh, I think I have my microphone on. Does this help?
Yes, sir.
One. Okay. Deputy McLeish, does this resolve all of the business at the Van Dyke County Justice Center today?
It does, Your Honor.
I thought you were mad at me and you were just not responding to me. So I was having the Rolodex in my head. Like I knew things I'd done, but I was like, which one was it? You know? So, all right, then we'll be adjourned and we'll resume criminal court on Thursday of this week.
Thank you.